You're on News Talk 820 WBAP. Hi, Quentin. How are you?
Good morning, Chris. How are you?
Good morning. Thanks.
Well, I'm here, and I guess you're leading up and teeing up Kennedy versus Bremerton School District.
Yeah, before we get into that one, I can't wait to ask you about that. Tell me about the abortion decision. Was it a good ruling in your opinion, and why?
Well, it's going to be in the eye of the beholder. So many people will look at that case through the prism of what they think about abortion. There was an argument that even some liberal, scholars and justices had made over the years that it was an overreach. It essentially was legislating. And so if you buy into that argument, setting aside the issue of whether or not you agree with abortion, which is very difficult to do, but I'm just talking about from a strictly legal point of view, there was an argument that Roe went about the way it went about what it did in the wrong way. In any case, that Dobbs case from last week overturning Roe, it's a loud and clear announcement. There's a new set of sheriffs in town.
Right on.
There's a new court.
Right on. And I think the other thing that's really important is, even Ruth Bader Ginsburg said it was a tenuous decision way back when.
Well, she did, and it's a famous quote. And in Europe, for example, the legislatures, by and large, have compromised. And in America, from 1973 on, because it was enshrined as a constitutional right, there was no ability or incentive to do that. So it's going to be very interesting to see what happens in the legislatures now. Some states had already preemptively moved to protect the women's right to abortion. Some had trigger laws, including Texas, that say as soon as Roe is overturned, then we go back basically to the status quo before Roe. So it's going to be very interesting. And then, of course, there may be a federal push now, particularly if we get a GOP president in. If Biden does not win re-election and, the midterms and the switch, if there's a switch in the Senate and the House, then you could have a push to enact a federal legislative ban against abortion.
Right. And I wanted to ask something else, too, that's really important. That's the whole thing, from my opinion, is the states and the states need to decide, because the Constitution's silent about it, which is what Kavanaugh said, and the justices on his side. But then also the states can decide. And, where the Constitution is silent, the states are to decide, or we can legislate it federally, as you just mentioned. Now, here's something else. People are mentioning interracial marriage, gay marriage, contraception. That could be next. But I saw that a University of Dallas legal scholar said that Justice Thomas's views on these cases are no surprise, because people that are familiar with his judicial thinking, he says things like this in the past, that the due process, equal protection laws, as establishing rights, the nation's founders never intended for those rights. So he's not saying that we got to strike down gay marriage or contraception or interracial marriage. He's just saying that this is the same tenuous way of deciding cases. Is that correct? And do you really think that that's going to be a possibility? Because these folks in here, the experts, say no, because none of the other justices are going to go after that. Your thoughts?
Is it a possibility? Certainly. And that's what the dissent raised, is you've opened Pandora's box. That's the argument. If you strike down Roe based on an argument and an analysis that substantive due process under the 14th Amendment doesn't guarantee that right, then other cases, including not limited to cases on birth control, right to engage in private consensual sex acts, and same-sex marriage, all those cases, the dissent said, potentially are at risk. Samuel Alito, the author of the majority opinion, attempted to limit the applicability of Dobbs, the case from last week overturning Roe. He said abortion is different because it destroys the life of an unborn human being.
Right.
And so he said none of these other substantive due process decisions are at risk simply based on this Dobbs opinion they issued last week. Now, Clarence Thomas, as you noted in his concurring opinion, said, no. I think we need to revisit all of them based on now Dobbs, and I don't think there is this substantive due process right. I think it was basically made up. It's not in the Constitution. That's what Thomas said.
Right on. Okay, now I wanted to ask you one more thing. I wanted to ask you about the decision that just came in. with regard to the case in Washington with Coach Joe Kennedy, high school coach, praying, not inviting anybody, not forcing anybody, not pressuring anybody or punishing them on the 50-yard line after the game. To me, this seems like a victory for religious liberty. What do you know about this case? And I know it just was decided in favor of the coach, which I think is fantastic. But what do you know about it, and what's your reaction?
Well, the opinion literally was released just minutes ago, so I haven't had a chance to read it. However, it does fit into a pattern. The court has been migrating, even before this new conservative majority of 6-3, towards allowing some expressions of religious prayer and other things, as long as they did not unduly infringe on the rights of somebody who did not want to participate. And this case involved a coach who was praying at the 50-yard line. I think he said that at the end of games. Mm-hmm. One parent complained out of a concern that the son, who was an atheist, might be denied playing time by not participating. And the court, it appears, has decided, and my guess would be, has decided that it was not an undue infringement on the rights of anybody, provided nobody was forced to participate in it.
Yeah, I would love for proof to be shown that he was punished for not participating, and that's an interesting fact. Now, here's one more thing I want to ask you. By the way, a fellow at the International Academy of Trial Lawyers, Quentin Brogdon, joining us. One more question for you before we have to let you go there. But CBS News poll: Americans react to overturning Roe v. Wade. Most disapprove, calling it a step backward. Here's my contention. Polls don't mean a darn thing. Plessy versus Ferguson, saying separate but equal for blacks and whites in the schools. You could have had a poll that would agree with that. Who wants to follow that poll, right? Polls don't matter when it comes to rulings for the Constitution of the United States Supreme Court, right?
You're right. You cannot have judges, whether you believe in what the court did last week or not. We all should be able to agree that judges should not be making their decisions based on polls and based on what a majority of the public wants or thinks the law requires. The judges should be guided only by what the law actually is in their fair and fairest interpretation of the law and the Constitution in this case.
Amen. I appreciate you very much. Attorney Quentin Brogdon, thanks for joining us today on the Andrew Brown Show. Chris Crock filling in. Appreciate you.